Hi, I'm Alder from Alder IP, and welcome to another episode of IP. Today we'll be talking about copyright and why copyright is a bit of a poor substitute for patents. Copyright is pretty much an intellectual property right that protects artistic works. It protects things like books, drawings, software code. What it actually protects is it protects the expression of the idea and not the idea itself. And this is a bit of a tricky concept to get your head around. It's not actually protecting what you're telling somebody, it's protecting how you tell it to them. A patent, on the other hand, protects a functional aspect of an invention that you create. And it actually protects the features that are in the scope of claims. So if you look at a patent document, there's a set of claims in the back of the patent, and each one of these claims has a number of features. So to infringe the actual patent, you need to copy all the features that are in at least one of the claims, and usually that's claim 1. The scope of protection between a patent and copyright is completely different. With a copyright type analysis, what we're looking at is whether the overall appearance or a substantial amount of the work has been copied. With a patent, it's whether it's strictly within the scope of the claims. And the patent covers the functional aspects of it, where the copyright only protects the way it actually looks or feels. Also, there's another problem with copyright in the fact that copyright dies the minute you industrially apply it to something. So then in time you make it into a physical thing, so if you make it into a piece of furniture or if you have an invention that you turn into a physical thing by an industrial process, you no longer have copyright in it. And there's plenty of examples of this where copyright has died because they've industrially applied it. And probably the biggest example is Lego bricks, where Lego bricks lost the copyright in the overall Lego brick, but they went for a design as well. So they had design protection as well. The take-home message is that copyright is a really poor substitute for patents. A patent gives you broad protection, and copyright only gives you very specific protection, very niche protection. It's also interesting to look at particularly software, and in software, a lot of people who write software rely on copyright as their primary source of intellectual property. And really what you have to ask yourself is, should I get patent protection for this piece of software before I release it? Because a patent will give you much superior rights to it because it'll cover anyone reverse engineering the software and not merely just copying the source code, because copyright's only going to stop them from exactly copying the source code, and it won't stop them from copying the output. I hope that helps you understand some of the differences between copyright and patents and understand why copyright is not the best thing to protect all your intellectual property with. If you need any more help with copyright or patents, please contact Alder IP on the links below. Thanks.